Good morning. We're delighted to be the first panel to start this two-day conference off today. And today we'll be talking about some issues, trends and developments that we are seeing in key global markets. And I'm very pleased to be joined by three industry experts in the class and collective action space. And perhaps we could start with each of you introducing yourselves. Rob, should we start with you?
Sure, thank you. So my name's Rob Jones. I work for Ankura. I'm based here in London. For those of you that don't know the firm, we are around 2,000 people globally. We're a multidisciplinary consultancy that focuses on complex disputes of all varieties, including class actions. I myself, I've worked in disputes and investigations for about 25 years on some fairly large class action matters on both the defence side and the claimant side. And really what we focus on is, in these sorts of situations, are three main questions, which are, what are the issues, how big are the actual claims, and how can those claims actually be resolved? So that's what we do.
Good morning, David Gadsden from Baker McKenzie in Toronto. Pleasure to be here and see all of you. I'm a class action defense lawyer. I practice commercial litigation more broadly, but with a specialty on class action defense. Act for defendants in all sorts of class actions, competition, securities law, cybersecurity, data breach, product liability, and also on both sides of the border. So we have, I act on Canadian matters, of course, but often I'll find myself on a team involving usually US lawyers where there's a parallel class action filed on both sides of the border. And so I work as a coordinated team advancing our clients' interests in a more global, holistic strategy rather than just in the localized context. Prior to Baker McKenzie, I also worked in class actions, but on the plaintiff side bar. So I started my career on the plaintiff side bar. And so I bring both perspectives to the table, and I think that's something that clients value, and it sounds like Rob's in the same boat. So pleasure to be here.
No, thank you. Nice to be here as well. My name is Bart Adriaan de Ruiter. I'm a partner in litigation at CMS. We are a global law firm. I'm part of our Global Class Action team. I also have a previous history at a plaintiff law firm for 16 years. I worked for NGOs. Also did some security litigations on the plaintiff side, and that knowledge we use now in the defense side to have a proactive approach and to look how we can manage that thoroughly. And we also have a class action report with nice data about that, which are at our desk here at the conference.
Great, nice plug there, Bart. Okay, so before we dive in, I just wanted to set the scene for our discussion today and provide some quick insights in the developments that we've seen at Broadridge in the past year. So it's been another busy year in the class and collective action space in terms of volume and value. And we've obviously seen significant developments in the management of claims, particularly here in the UK. And also that interesting funding decision, which I'm sure will be mentioned many, many times during the next couple of days. But the work that we do for our client base is very much dictated by the market trends and the market developments. And before I ask the panel their thoughts, I just want to summarize some of the key points that we've seen working with our clients. And the first is in the securities class action space, where there's been a notable increase in the value of claims, with the highest number of settlements this year exceeding $100 million in recoveries. And with that, we've also seen an increase in the volume, so more cases relating to financial antitrust, data breaches, ESG failures, and now cryptocurrencies. And with that, one of the last points I'd like to make about US is that the rise of the opt-out litigations that we're also seeing, so where the more larger, sophisticated investors will now bring direct actions against the defendants. The second point is shareholder activism. So this change in investor behaviour has really picked up its pace recently, whereby institutional and other investors are increasingly regarding class actions brought by ESG failures as a mechanism to really drive that corporate governance change in the companies that they are long-term investors in. The third point is the expansion of jurisdictions. It's something that we monitor closely. We've seen the adoption of the EU directive by some of the member states, and of course this will affect a lot of the work that we all do. But also recent proposed legislative changes in other jurisdictions. So in Germany, for example, Germany are looking to improve the efficiency of the CAPMUG proceedings, which is, well, I certainly believe it's a very welcome change. But in other jurisdictions, specifically like New Zealand and Singapore, they're looking to introduce statutory frameworks for the protection of consumers and investors. The fourth point is the increased participation in opt-in litigation. So this year at Broadridge, we've probably looked at over 100 collective action claims, with around 30% of those here in Europe. And this increase is very much driven by ESG factors, especially those that are more egregious in nature, I would say. But the range of options that are now available for claimants is definitely on the rise. And of course, litigation funding is a game changer in terms of the opportunities that are now available for claimants. And of course, this rise in the volume of funders in the market with significant budgets is, I think, really sort of making this concept of access to justice a very real one. And also we're seeing, you know, US law firms, US plaintiff law firms opening up offices in Europe. We're seeing boutique firms now doing more class action work, and traditional defense firms that are now taking on a lot more sort of plaintiff work. So I think all of these factors certainly contribute to the level of participation that we're now seeing. And my final point is obviously the competition claims are reaching new heights now, and we will discuss that in detail in a second. But the Court of Appeal decision last year, which was updated again last week, in the FX claims now moving to an opt-out basis, is something that is of particular interest to us, and I think adds to this opportunities to well, it sort of creates this equitable platform, I think, for businesses and for individuals. So we'll certainly be keeping an eye on that. Right, let's introduce some more voices now. So with that, I'd like to start with asking our panel specifically about recent developments that they are seeing. Rob, Ankura is involved in class actions in multiple jurisdictions, working on both sides. So from your perspective, how are these jurisdictional developments influencing the way that class actions are managed?
Well, I just wanted to echo something that you said there, okay, which is that, you know, that we just see class actions increasing in number. I think when you look at the sort of, you know, just what's going on in the world at the moment, in addition to all of these sort of game-changing devices which open things up, there's also an increasing awareness that, you know, and recognition of things which are not right, that there's, you know, there is this access to justice, this way of resolving some of these issues, and therefore I think a bit more, you know, sort of keenness to do something about it. There's also, I think, broadly speaking, across all of the different jurisdictions, a sort of a staggered path in terms of the way that the regimes have developed. So not every single, there's no one single regime which is perfect, and we're all kind of like learning from each other, looking overseas, looking at how do they do things over there, how do they do things in the US, how do they do things in the States. I think the thread that runs through all of the different regimes is that, you know, we all think that there's a reason to improve integrity, fairness, efficiency in all of these regimes, but not a single one of us wants to be like the US, sorry. And you know, with that, because there is this, you know, sort of sort of diversity in the way that the regimes actually work, and we're all sort of learning from each other. We're seeing quite a lot of interesting developments in particular jurisdictions, which range from the very informal sort of discussions, which are kind of like, hey, look, these are kind of some of the challenges that we're seeing here that we haven't really encountered before. I was dealing with something last week with a client who was essentially looking at a budgeting issue because the other side had put forward, just keeping it as simple as I can, put forward a proposal for a certain exercise which had an astronomical figure attached to it, and it was almost very, very clear that they hadn't really brought any sophistication to their thinking around how they were actually going to tackle this particular challenge. They hadn't necessarily thought about using any technology and so on to work their way down to a sort of a more reasonable kind of number there. And then that goes all the way up to the sort of the more formal exchanges of knowledge. So, for example, here in the UK, we have something called the Collective Redress Lawyers Association, which very much has integrity, fairness and efficiency at the centre of what it's trying to do in terms of improving the way that the class actions regime works here. But we haven't, perhaps it's too soon here, but we haven't yet seen what we sort of see in Australia, for example, where there's the Australian Law Reform Commission has done a lot of thinking about this. I'll just pause there.
Great. So it's interesting, the collaboration knowledge share point that you make, actually, Rob, because it sounds like it's been in the pipe for some time and it's now just sort of coming into fruition. And it certainly it sounds like it's bringing efficiency and sort of joint expertise. And I think from a claimant's perspective, it just allows them to sort of focus on good claims, viable claims, and ones that stand a chance of success.
Exactly right, yeah, and so there's an economic principle that sort of underlines all of these things, which is exactly how do you make these claims work successfully, but there's also as the regimes develop, and certainly here in the UK we're seeing a lot more success in the Competition Appeal Tribunal, more cases being certified. That also gives quite a lot of confidence to the claimant bar, so that they're able to then apply more pressure to the defendants, ultimately looking to try and settle some of these cases earlier on, or as early as possible in the process.
Great, okay. And Dave, sticking with this point, what kind of trends are you seeing in the Claimant Bar Council in Canada? Yeah,
so let me pick up on some of what Rob's just said in terms of the collaboration that we're seeing. So don't get me wrong, in Canada, plaintiff class action firms are very much competing with each other still. Just a comment on generally what the landscape looks like. In Canada, there's, I'll say, relatively few plaintiff side class action firms. And that's because it's a very highly specialized area. It can obviously be a very lucrative area for class counsel, but it comes with a lot of risk. These cases are very hard fought. Of course, counsel do not get paid until there's some sort of success in the claim, whether or not that's by way of settlement or a positive judgment at the end of the day. But in any case, the expertise is required, and these are long fought and hard fought battles. Having said all that, we do see a bit of a trend in Canada where, particularly for national class actions, where you're bringing class actions on behalf of Canadians everywhere rather than a particular province, which seems to be more and more the case. We're seeing that class counsel firms, plaintiff side firms, are collaborating with each other. And they're doing this in a few different ways. I mean, one way that might be obvious is they will team up and form a national consortium. So you might have a plaintiff side firm from Ontario and Quebec and British Columbia kind of collectively file actions in each of those jurisdictions, but on behalf of all Canadians everywhere. And then what they'll do is they'll collaborate. They'll pool their resources, pool their knowledge, and they will decide strategically to perhaps stay the proceedings in two of the jurisdictions, but move forward in the third. hoping to drive a result that ultimately will end up resolving all 3 actions. And so it's like I said, this doesn't happen all the time. These firms are very much still competing with each other. But we are seeing a lot of collaboration. And frankly, on the defense side, it's actually made life easier for defendants. The trend previously was, particularly with national class actions, it would be like a whack-a-mole situation. You have actions popping up in different jurisdictions, none of them working together or being coordinated in any fashion. And on the defense side, that puts you in a position where you're unfairly, I would say, trying to defend the exact same proceeding in 4 or 5 different jurisdictions. So the defense side, we certainly welcome that collaboration, and it's something that we're happy with as well.
Great, okay. And Bart, we've seen a fair amount of headlines coming out the Netherlands quite recently. We've seen large security litigation settlements, we've seen important environmental judgments being handed down, and of course the directive came into force on the 1st of September. And I just read something that you wrote recently in the Dutch press, and I just wanted to ask you, going along with that theme, are the Dutch courts a claims paradise, as you mentioned in your article?
Oh, I think I did not mention that. No, what I said was that since 2020 there's a new system, a class action system in the Netherlands. It's an opt-out mechanism for the Dutch parties and an opt-in mechanism for foreign parties. And there is a really balanced system also with regard to the defendants, but that the plaintiff side needs to have knowledge, and the class action foundation are really handled very strictly towards the court. What we see in the last judgment of September in the Airbus case, that we saw that a claim was dismissed because the foundation was not being professional enough and had enough knowledge about the market. So we see a very high, getting maturer, a very balanced system. And what we see on the plaintiff side, on the collaboration, which you just said, on the Plaintiff Bar Association is just founded a couple of weeks ago in the Netherlands, and we see also a lot of other kind of developments which underline this maturization of the market.
And do you think there's a danger of the Dutch courts becoming flooded? Because it is generally a very claimant-friendly jurisdiction. I mean, where do you see all that?
We see a small rise in claims. We don't see that development yet in the market, based on the objective figures. Mm-hmm. And everything is transparent in the class action register, so we can exactly see what's happening. Half of the claims is still cartel claims and consumer products and things like that, and the rest is ESG claims and things like that. But that can rise significantly the next years, depending on legislation and things like that in the ESG, on the ESG side, and perhaps also on the securities litigation side.
Mm-hmm. Okay. Right, I'd like to turn to the dark side now, if I may, and circle back to one of the points that Rob made about this this pressure for defendants to sort of settle early, with that sort of collaboration point that you made. And Rob, with the work that you do, how have these developments been received by defendants, and are we seeing a shift now?
I think we are seeing a shift, yes. At one time, I think there would have been a certain sort of reticence to collaborate, perhaps, and perhaps a bit more, more tendency to sort of be entrenched and to really fight some of these claims. And some of the cases that we see at the moment, have been going through the courts for years. And so, I think that's still going to happen. I think still that some cases are going to be very, very hard fought. Because the issues are so big and the sums of money are so huge. But one thing which is also quite clear over the last couple of years at least is that that there is an opportunity as a defendant to really kind of get on the front foot of what's going on. And so I think, if you're a board that's managing litigation at the moment and looking at all of the different, all of the management information you've got your hands on is going to tell you that some of these cases are going to be very, very expensive to run, and so that means that you do have to make some fairly careful decisions about the course of action that you're going to take. So, just very broadly, and not necessarily just related to class actions, but I've seen boards taking, fairly sort of early decisions and early steps to investigate issues that they are worried about inside of their businesses. So this is asking that first question: do I have a problem? And so, they might use internal investigations tools and so on to figure out what's actually, is there any smoke? Sorry, the smoke, but is there any fire? And assuming that there is some fire, then there are also, one needs to find out, well, where is the fire and how big is it? And so that's where they are turning to using, sort of economists and damages experts to do, various sort of modelling of the different scenarios to try and figure out actually how big is this particular fire, and how hot is it going to get, and then. That then sort of leads you on to the sort of third question, which is, what are we going to do about it? And one of the answers may still be that we're going to fight this tooth and nail. We're going to litigate it for as long as we possibly can, in the hope that it exhausts the claimant's resources and so on. But actually, the world is changing, and I think that there's a reputation factor here which is really, really important to keep in mind. And some cases, I think, might just tip the balance in terms of, the cost with which it's likely, they're likely to spend on running it, the likely outcome that they might have after potentially decades of litigation, and the reputational harm which they actually suffer as part of that. There are now access to more sort of services, more expertise, more help and guidance, which means that, litigation isn't always going to be, or long-term litigation is not the answer, but early settlement might actually be something that they can write the narrative for, that they can actually drive that, and they can sort of effectively de-risk their own sort of litigation ledger, if you like, to bring about a swifter, sort of better resolution for everyone.
Yeah. I mean, I think the ability to be able to establish potential exposure and liability at an early stage is an obvious advantage, to try and encourage those early settlements. And Bart, this point that Rob mentioned about this proactive risk assessment, is that something that you're also seeing over in the Netherlands?
Yes, but of course, that's what we do also at the CMS, to look at it at a global or European level, to look at the heat map from what are the jurisdictions, what are the options, and how can you handle that as a defendant proactively, and which jurisdiction is more profitable for our position than others, and then you can fasten the process or slow down where you want to have a proactive approach.
Yeah.
So that's what we see as well. Yeah.
Okay, that makes sense. Dave, so I'd be interested to hear your thoughts actually on this, because you've obviously worked on both sides, defendant and claimant. So what are we seeing on both sides of the courtroom in Canada at the moment? And perhaps you could talk a little bit about the sort of interplay between Canada and the other jurisdictions as well.
Sure. So similar to Rob's comments, there is a scenario, and there's a context in Canada where in the right case, it does make sense for defendants to get out in front of it and settle early. And the reputational point is a great one. I think in today's day and age, in a world where corporate behavior is scrutinized very closely and very publicly, I think companies, and we're finding with our clients, the reputational concern is a real one. The other aspect that comes into play, though, is in Canada, the bar to certification is quite low. And I would say if there is a trend, it's actually that bar is getting lower. And so what does that mean from the defense perspective? Certainly in certain areas of class action, so I'll use competition, for example, the bar is quite low. And I would say the percentage of claims that are getting past the certification bar, probably in the 85 to 95% range. And so if you're advising your client on the defense side what to do in that scenario, I think a lot of times you're still going to get instructions to go and fight that tooth and nail and you know, draw with the litigation as much as you can, make life difficult for the plaintiff side, and put forward whatever novel arguments you might make that would distinguish your case from the others that have come before it in helping to set that low bar. But we are finding that increasingly our clients are willing to perhaps consent to certification or consent to certain aspects of the certification test. And that's not viewed necessarily as a significant concession in all cases. What it really is the defendant saying, okay, we know that we're unlikely to win at certification. We know that we're going to spend a lot of money and a lot of time going down that road, ultimately to find that this is something that's going to be certified. Why don't we just, you know, consent to that portion of the process and get onto the real battleground and fight the claim on the merits? Because, of course, there's a big difference. The certification is completely a procedural aspect, and it has nothing to do or very little to do with the actual merits of the case. So just because a case is certified doesn't mean that the plaintiffs are likely to succeed at trial. So often we're seeing now defendants are willing to consent to certification or parts of certification just because it is such a low bar and there's a desire to get on to the real fight. And then, you know, I will say before moving on from that point, we do get directions from the court, and we see case law coming out from the court still that does remind all parties that, you know, despite the fact that it's a relatively low bar, it's not a rubber stamp process in Canada. The court plays a very important gatekeeping function to make sure that only the cases that are actually going to benefit from the class action regime do get through that process. And then on the plaintiff side, we are seeing that there's, and this is something that hits close to home for me because I practice in the province of Ontario. In Ontario, the legislation that governs class actions was recently amended, and the amendments incorporated a couple of concepts from the US class certification test that arguably make the bar increase a little bit and make it a little less plaintiff friendly. So we are seeing a lot of plaintiffs now, and this goes back to my collaboration point, a lot of plaintiffs are teaming up with counsel from other provinces and filing cases primarily in British Columbia, which still has I would say the lowest bar in Canada. And so that's a really interesting development that we're seeing, and it's interesting for plaintiff side class action firms in Ontario because a lot of the work that they would normally be doing it seems to be, you know, drifting elsewhere to other more plaintiff-friendly jurisdictions.
Okay, interesting development. Sounds like other jurisdictions will continue to watch what you guys are up to. I just want to come back to one of the points you made, Rob, about damage analysis and quantum. And from our experience, particularly with some of the more complex cases, being able to translate something like quantum is very, very difficult. So obviously but I'm certainly not an economic expert, but when we have cases, you know, like I mentioned, for example, with the FX case, when we receive those damage analysis back, the first job is to try and understand, or try and get a slight grip of the methodology that's being used, and then being able to translate that to your clients is, of course, very difficult because many of our clients may say, these figures are astronomical. We can't seem to quantify this. It kind of doesn't make much sense to us. How do you sort of reconcile with with those, you know, with that problem?
This is probably a good time for me to say that I'm not an economist either, but I do work with economists, and their work is absolutely fascinating and also integral to this whole area. I think it's the economists I work with are fairly sort of agnostic in terms of which side of the fence they work on, because actually, you know, their job focuses on numbers and data and the way that you analyze data to deliver the best information for decision making. So it's equally applicable on both sides of the fence. But if you take, for example, the Lloyd and Google decision. Just for a second, there were some interesting comments from the Supreme Court there around the idea of this sort of bifurcation of proceedings, and I think that the market here received that as a bit of a red flag. I think a lot of funders got cold feet because actually the way that you slice and dice the kind of the cohorts involved in cases like those makes it, at first glance, it makes it look quite difficult. Difficult as a prospect to actually fund it, difficult as a prospect to sort of see any real success coming from it, and managing it in an economically viable kind of way. However, one of the things which our economists are very often asked to do is to look at very large swathes of data where there is a lot of variation throughout the group, and to really kind of segment that into different subgroups, if you like. So something that can and does often happen is that the economists can sort of help you to identify, and this works either way, whether you're claimant side or defense side. It helps you just to identify where there are, pockets of, viable claims essentially that could be run. So if you're thinking about how do I get this case off of the ground, how do I, put a compelling case to the funder, and just for argument's sake, you've got 1 million people, but through that there's a segment of maybe 500,000 or 600,000 people that that are very close. Closely matched, then that suddenly becomes a bit more of a kind of an interesting proposition, rather than trying to sort of boil the ocean and litigate on behalf of the full million. There's that, and then actually if you're on the defense side of things, you'd be looking at it to sort of say, well, actually, do we have a problem here, and how big is it? It's not enough to say, well, actually that will never fly. What the smart play is to sort of see is, well, actually, how could it fly? How could the claimants actually have some success here? And if they're looking to try and segment, the cohorts into sort of more manageable groups, then with the assistance of an economist, then you might say, actually, that presents sufficient risk that we need to defend against.
And Dave, have you sort of come across this as well in your line of work, in terms of being able to sort of translate those, quantum figures in a meaningful way, I guess?
It's a challenge, and I'm also not an economist, just to get that disclaimer out there. But, I mean, where I see it a lot is in the context of competition class actions in Canada. Interestingly, there's been a real proliferation in competition class actions being filed and pursued by plaintiffs, but there's never been one gone to a trial on the merits. The reason for that, plaintiffs' counsel might tell you, is because often these cases are started or triggered by some sort of regulatory finding, whether it's in Canada, the US, or elsewhere, a finding of guilt on the part of the defendants, and to, the price-fixing conspiracy is a classic category that we see this in. And so, the defendants have admitted guilt elsewhere in the world to some of these claims that are being brought against them. So, long way of saying, often those cases end up in a settlement of one form or another. But at the certification stage, there is a big battle with respect to damages. It's procedural. It's not finding out exactly what the quantum is, but the plaintiffs are charged with the onus of convincing the court that there is a workable methodology, a plausible methodology that will allow an economist at the end of the day, if there is a finding for the plaintiffs at the end of the trial, that will allow them to calculate damages on that can be attributed to the various levels of claims, so direct purchaser claims, indirect purchaser claims, umbrella purchaser claims. And so, frustratingly, from the defendant's perspective, at the certification stage, we can challenge that methodology, but the courts have explicitly said it's not a battle of the experts. So we're going to look closely at the methodology enough to know that it appears plausible, it appears workable. It's likely going to be possible at the end of the day to calculate damages on a class member basis if there's a judgment against the defendants. But to date, that just hasn't been tested yet. So while the certification judges will say, yes, it seems like there's a plausible way of doing this, because we haven't had a merits decision on the issue, we haven't had that battle of the experts, so we haven't figured out, is it actually possible to do it in a way that's fair and reasonable? So that's the area that I find most relates to what Rob was discussing, and it's a matter of time. Like, there will be a competition case that goes to the merits, and very much looking forward to that guidance from the courts once we get there.
Bart, do you have any comments to make on that?
Yeah, I agree with your point of view. Yeah, as I said, the new class action mechanism just was introduced as per 2020, so we're not in that phase. We don't have that experience yet. Mm-hmm. But it is work for economists, and like the plausibility and the causal connection is always a hot topic in that respect.
Okay. So now I want to turn to what we'll be seeing on the horizon. And I think given what we've discussed today, it seems to me there's now this sense of like claimant empowerment, with the types of cases that we're seeing, the variety of cases that we're seeing, and some of the points that you guys have made in terms of the process for being able to bring mass claims. There's the expertise there now. There's the technology there that's able to manage a claim from start to finish, and obviously I think we're going to be talking about it later, but that the sort of disbursement stage is very, very difficult, and it seems like we now have the right mechanisms in place to be able to deliver, so it all seems to be moving in the right direction. And could I ask each of you to summarise your thoughts on what you think the future may hold in this space? Rob, if we start with you.
Sure. Well, I think it's a given that we'll see more claims. I mean, our firm's involved in many more different types of claims beyond what we're sort of seeing in the UK. So we've handled things like death and personal injury cases. We've handled a lot of tortious claims. Something which I know is being talked about quite a lot is the PFAS litigation, which is very prevalent in the US, which might actually sort of make its way over here. So I think there will be lots more claims, but I think with that we'll also see, perhaps in the more immediate term, we'll see more issues in the case management. I suspect that because we're at the moment in the UK, we're handling things in a linear kind of fashion. We haven't fully worked our way through to the distribution of funds stage yet. I think there will be some surprises and some challenges which arise at that end of the spectrum. So perhaps around sort of budgeting and so on, and the actual cost of running a redress scheme from start to finish. And like I said before, I think that with the increased pressure on defendants, I think we will see, or maybe we won't necessarily see it, but we'll perhaps quietly notice that there'll be more voluntary settlements actually happening alongside those cases which are, sort of hard fought in the public eye.
Mm-hmm. Okay.
Yeah, so I think what's on the horizon in Canada, I think there's three categories of action that we're seeing a real increase in and real development in. One is ESG, and we've talked about it. Given the public scrutiny that is applying to the corporate world now, and rightfully so, given the world that we live in with climate change being front and center, what we're finding is that corporations are now essentially competing on ESG claims, right? It's part of their value proposition that they're putting out there to the market. So with that comes a lot of scrutiny, both by regulators and also by the plaintiff side bar, right? So both of those entities are looking very closely to make sure that the ESG claims that are being put out to the world by corporations are valid and something that is actually being lived up to. So we're seeing a lot of cases in that area. The keynote speaker, Justice Waxman, mentioned the diesel emissions case. I would say that would be that's a few years back now, but that would be the highest profile of those cases. So I just expect that area is just going to continue to blossom and grow. The other area is cybersecurity and data breach claims. We're in such a virtual world now. I think half of our participants today are attending virtually. It's no surprise that cybersecurity is a real risk for corporate defendants. And so we're seeing lots of claims, lots of development in the area. In Ontario, a few years back, a new privacy tort was created. It's called intrusion upon seclusion. Essentially, if a plaintiff can demonstrate that someone has intruded on their privacy or invaded their privacy intentionally and in a way that's essentially morally wrong or likely to cause embarrassment or humiliation or damage, then they may be entitled to some sort of damages claim. And so, interestingly, the Ontario Court of Appeal about a year and a half ago came down with a trilogy of cases on that issue. And in that trilogy of cases, it involved outside hackers hacking a defendant's database, accessing information of employees. And the interesting development there was that the courts ruled that those defendants that hosted the database could not be held liable on the intrusion upon seclusion tort because they weren't the ones actually invading the privacy or intruding on the privacy of the employees of the company. It was actually the third-party hacker. Now, there are still negligence claims and other claims available against the corporate defendants, but that's an interesting development that we'll see now play out now that we have Court of Appeal guidance. In the privacy space, there's a lot of claims. The caveat I'll put on that one is there's still not much in the way of traction on large damages amounts. So often these claims will be brought forward, they'll be certified, and plaintiffs may be successful, but there's a real question about how do you quantify the damages of having your personal information having been accessed by a third party. It all depends on the facts, of course, but a lot of cases we're seeing at the end of the day, there's not much in the way of large compensation for plaintiffs, and that will be interesting to see if plaintiffs' counsel continue to push those cases forward. And then the last thing I'll say is, it's another obvious one, but in the crypto space, we are seeing a lot of increase in crypto claims. It's obviously in Canada anyway, it's still the regulation of cryptocurrency is very much in its infancy. So it leads to lots of opportunity and lots of claims accordingly. So we're seeing a lot of claims be filed, and we just don't have the guidance yet from the courts as to how those are going to play out. But watch that space.
And Bart?
Yeah, I agree with David. You're the front runners in class action, so those trends will fly over the ocean towards us. But furthermore, I see globalization of class actions. You see now certain hotspots of class actions in Europe, UK, Netherlands, Germany, Portugal. But what we see is that all other jurisdictions, and especially opt-out mechanisms, are increasing significantly. I expect that to rise the coming years, also due to technology, but what makes it more easy to build classes, to build cases. Technology is really an accelerator, I believe, of class actions. And with regard to the type of claims you mentioned, I agree with what you said, but I think mostly the ESG type of claims will rise significantly, especially in the areas of the world where there is a lot of acceleration of climate change, like where forest fires in the US, Australia, we see a lot of actions in that regard, and that will also come to this side of the ocean, unfortunately, also due to stricter regulations in that respect. And we see also from the people of the world more activism in that regard. Yesterday there was the biggest climate demonstration ever in the Netherlands. So you see that kind of type of activism really accelerates class actions in the end. So that's what I expect to be the biggest driver for that type of claims. And next to that, of course, the commercial-driven class actions, consumer products, and cartel claims.
And I think just the final thing for me is from a securities litigation perspective, the decisions in cases that specifically you mentioned, David, Rob, the Google decision, where there could be a two-stage model offered. You know, there's talk that it could be also applied to Section 19, Section 98 FISMA claims, which for us is extremely interesting. So we're looking to the High Court at the moment to see how that is going to play out, and if it does become a reality, because I think it's certainly going to become a game changer in how the security space is managed. I think that we are now out of time, I'm afraid, so I would really like to thank our panel for their thoughts, their insights, some really interesting points made, lots for us to consider, so thank you very much. Thank you.
Thank you.